ಶುರುವಾಕಿಂತ ಮುಂಚೆ ನಾನು ಮೊದಲಿಗೆ ಪರಿಚಯ ಮಾಡಿಕೊಡ್ತೀನಿ. ಕೃಷ್ಣನ್ ವೆಂಕಟರಾಮನ್ ಅವರು ಮೊದಲಿಗೆ ಒಂದು ಸೆಕೆಂಡ್. ಶ್ರೀ ಕೃಷ್ಣನ್ ವೆಂಕಟರಾಮನ್ ಅವರು ನಮ್ಮ ಲಾ ಮುಗಿಸ್ಕೊಂಡು MS or Engineering Science Harvard University ಮುಗಿಸಿದ್ರು. Has completed his engineering from the Harvard University Cambridge, including coursework and MIT also. His professional experience is in arbitration and litigation and contract management and drafting of agreement. In that he in arbitration and litigation he is advising on contract management of engineering contract, working extensively with the National Highways Authority of India (NHAI) and other public bodies in the dispute resolution arising out of large infrastructure projects. And in the contract management, serving the contract management requirements for various projects. Present activities include arguing cases before DRBs and arbitral tribunals, and drafting pleadings, researching and validity and feasibility of claims. In academic interest, he worked in the public systems group on the analysis of the infrastructure and telecom sectors. The outcomes of the analysis were published in various reputed journals and books also. His indicative list of clients are NHAI, BS, RDCL, L&T IDPL, L&T ECC, Reliance Infrastructure Limited, JMR, ILFS Engineering, BSCPL and other major organizations. They are the clients of the Shri Krishnan Venkataraman. Once again I welcome Shri Krishnan Venkataraman ji. And today's this webinar presiding by the Shri Professor Bhattu Satyanarayan ji. He is a Vice Chancellor, Central University of Karnataka. Professor Bhattu Satyanarayan was born at Bomakkal village, Karimnagar district, Telangana state. He has obtained his MSc and PhD degrees from Osmania University. He got the CSIR JR through the examination conducted by CSIR. He served as a lecturer at Indira Gandhi National University, New Delhi, assistant professor, associate professor, and professor in the Department of Chemistry, Osmania University, Hyderabad. He has 32 years of experience at UG and PG teaching and 36 years of research experience. So he has guided 18 students for their PhD degree. He has published 80 research papers in peer-reviewed journals. His area of research includes coordination chemistry, analytical chemistry, pharmaceutical chemistry, catalysis, inorganic chemistry, nanomaterials, and environmental chemistry. Presently, he is as I mentioned, this is a Vice Chancellor, Central University of Karnataka, Kalburgi. Sir, I once again welcome you. Thank you. ಮತ್ತೊಮ್ಮೆ ಎಲ್ಲರಿಗೂ ಸ್ವಾಗತ ಕೋರುತ್ತಾ I request Shri Madhave Kradali to take over.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ನಾವು ಈ ವೆಬಿನಾರ್ ಅನ್ನ ಅಂದ್ರೆ ಆನ್ಲೈನ್ ಉಪನ್ಯಾಸಗಳನ್ನ ಮರ್ತೂರಿನ ವಿಜ್ಞಾನೇಶ್ವರ್ಗೆ ಗೌರವ ಸಲ್ಲಿಸಲಿಕ್ಕೆ ಚಾಳುಕ್ಯ ಚಕ್ರವರ್ತಿ 6 ವಿಕ್ರಮಾದಿತ್ಯರು ಕಲಬುರಗಿಗೆ ಬಂದು 900 ವರ್ಷಗಳಾದವು ಅನ್ನೋದ್ರ ಸಂದರ್ಭದಲ್ಲಿ ನಾವು ಇದನ್ನ ಆಚರಿಸ್ತಾ ಇದ್ದೇವೆ. ಸೊ ಈ ಕಾಲಖಂಡದಲ್ಲಿ ನಾವು ಅವ್ರ ಜೊತೆ ಇದ್ದೀವಿ ಅನ್ನೋದೇ ಒಂದು ನಮ್ಮೆಲ್ಲರ ಸೌಭಾಗ್ಯ. ಮಿತಾಕ್ಷರ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಿತ್ತು, ಆದ್ರೆ ಮಿತಾಕ್ಷರ ಕರ್ತೃ ಯಾರು ಅನ್ನೋದು ಗೊತ್ತಿರಲಿಲ್ಲ. ಅದು ಮರ್ತೂರು ಶಾಸನದಿಂದ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಸುಹೌಸರ್ ಪರ್ 900 years before Chalukya Vikramaditya, the most strong king of the Bharata, who visited Martur to honor the Mitakshara Kartru Vijnaneshwara. So we are celebrating by arranging this webinars on in Bharatiya jurisprudence. So the unique occasion it is, yesterday we celebrated both physically and online. Our Honorable Senior Justice of High Court of Karnataka, Kalburgi, and Honorable District Judge of Kalburgi were present, along with Sri Basaraj Patil Sedam, former MP of Rajya Sabha. So this occasion should celebrate by knowing the Indian jurisprudence and its relevance today. So Mitakshara is relevant all over India, other than West Bengal and Kerala, where Dayabaga, written by G. Mutavana, is operating. We can ascertain that after 900 years also, Mitakshara law is followed by all courts in and out of India. So by studying Mitakshara, we are not only studying Hindu law, but we are studying the civilized society, how it was, how it is operating in India. He has got human values in law. This is the specialty of Vignaneshwara. After Vignaneshwara, I think more than 6 dozens of scholars referred that Mitakshara, which was written in few words or sentences, but it is referred by all the upcoming jurists. So now during this transparency period about centuries old, we want to re-establish the Bharatiya jurisprudence to the people of legal community, not only legal community, but also common man. So we request Sri Krishnan to come to us. He is giving lecture on it, and we requested Honorable Vice Chancellor. So he also he has attended now. We congratulate and thanks for both their joining Vignaneshwara Pratisthana program and legal advocates in legal judiciary field and legal experts of judicial field and teachers, lecturers, principals, whoever presented here. I welcome on behalf of Vignaneshwara Pratisthana and request Mr. Krishnan sir to continue his talk. It will be continued tomorrow also. Thank you.
Dhanyawad, sir. May I request Sri Krishnan Venkatraman sir to deliver his speech, whereafter there will be a question and answer session and also the Honorable President's remarks. Thereafter the vote of thanks for today. Mr. Krishnan sir, please over to you.
Thank you. Once again, express my gratitude to the Vignaneshwara Pratisthana Trust for having organized this kind of a session so that there can be a greater sensitizing of public at large with regard to the thoughts and the approach of law that had been prevalent in our country. And we had started yesterday with certain readings, first-hand readings of the text of Vignaneshwara. This is proposed to be continued today. I also express my respects to the Honorable Vice Chancellor of the Central University who is present with us. And with that, I continue with where I left off yesterday. Just before I continue, I should bring to the notice of all of those present here, including the organizers, that I had received a book published last year by the Karnataka State Law University. This is something that I received and it came to my notice yesterday. The title of this book is Socio-Legal Values in Mitakshara, Vachana, Dasa and Folk Literature in Karnataka. So there has been ongoing, just to point out, because today we are talking about the relevance and contemporary aspects of Mitakshara. So there has been ongoing interest, and it appears that Karnataka and the land that we today know as Karnataka has continued to play a leading role in this kind of an discovery and a show of interest. So with that, so this book is published just recently, last year, in 2022. So in the first two provisions, I'll call them provisions or verses in the Yajnavalkya Smriti, yesterday we had seen that the Drupa, king, or any ruler or any executive who is charged with the well-being of a society has to ensure that there is effective dispute resolution, because effective dispute resolution is the key to ensuring that society is organized and administered in a meaningful manner. And in that we had seen the establishment of a committee, a judicial committee of Sabhasadas. That was the first point. पहले हमने सभासदों के नियुक्ति के बारे में पढ़ा था. Today we will continue in that same sense. Vyavaharan nrupah pashyet ityuktam tatra anukalpamaha. So there is an additional aspect that has to be added. Apart from the establishment of the Sabha, along with the committee members, there is also an additional chief judicial representative that is mentioned here. Apashyata karyavashat vyavaharan nrupenato sabhyai sahan yoktavyo brahmana sarvadharmavit. So here we are talking about an important post which is equivalent to that of a chief judge or the presiding member of the committee. So apashyata karyavashat, due to other exigencies, if the ruler himself or the executive himself is directly unable to ensure administration of dispute resolution, along with the sabhyas, along with the members of the sabha, he has to appoint a magistrate or a judge who is to be a brahmana and who has to have knowledge of all the various dharmas. So that is now discussed by Vijnaneshwara in the Mitakshara. Karyantara vyakulataya vyavaharan apashyata nrupena purvoktaihi sabhyai saha sarva dharmavit sarvan dharman shastroktan samayikanscha dharman eti vicharayati iti sarva dharmavit. So what is the qualification for a person who has to be the chief judicial member, who has to be the representative of the executive? So one aspect that we have seen in the method of judicial administration as propounded in Yajnavalkya Smriti and as also commented upon by Vijnaneshwara in the Mitakshara, we do see, we are able to see that there is a stress that although the judicial actions have to be independent, there is no strict separation between the judicial and the executive powers. The executive does have the final say and has the final responsibility for ensuring judicial administration. That is the kind of system that has been prevalent apparently during the period of the Vijnaneshwara's system being prevalent. So the Karyantara vyakulataya, because of various other activities that the ruler, the executive himself is occupied with, Vyavaharan apashyata, he is unable to directly look into judicial administration. Then Nrupa, or the executive, or the person with whom the power of administration of the society is residing, Purvoktaihi sabhyai saha, along with the members of the appointed members of the Sabha, judicial committee, Sarva Dharmavit, there has to be a chief member there. Sarvan Dharman Shastroktan Samayikanscha Dharman Veti. So this person has to have knowledge of all the various dharmas which are mentioned in the Shastras and are also prevalent in society, even if they are not specifically mentioned in the Shastras. Dharman Veti. The meaning of knowing is that he is contemplating, he is applying his mind to it, and he is thinking about it. And that is the kind of quality that the engagement with the Shastra brings about. So reading a Shastra does not mean just reading what is there in the text there, but contemplating on what is there so that that becomes effective even in practice. Vicharayati iti dharmavit, sarva dharmavit. So here, of course, as we have seen even yesterday, Vijnaneshwara points out that it has to be a Brahmana, na kshatriyadir niyoktavyo vyavahara darshane. So it has to be somebody who is not part of the political class, not a kshatriya, but somebody who is part of the academic class, the Brahmana. It has to be such a person who has to be kept in charge of this aspect of overall supervision of the Sabha. Tamcha Katyayana Ukta Guna Vishishtam Kuryat. So a previous commentator, Katyayana, has explained in detail about what are the kind of qualities that are expected in a chief judge. Yathaha Dantam. So Dantam means he is in control of his senses. He is not given to pandering to his senses, sensual pleasures. Kulinam. He is coming from a family which, so therefore he has a fear of keeping up his family reputation as well. Kulinam. Madhyastham. He doesn't have to be prejudiced towards either side. He is unaffected by various prejudices. Madhyastham anudvegakaram. He is not to be disturbed, or he does not cause disturbance by his presence. Anudvegakaram sthiram. He has to be stable in his approach to problems or dealing with society. Sthiram. Paratra bhirum. He should not be indulging in interest about other people's wealth or other people's business. So paratra bhirum. Dharmishtham. He has to be established, his mind has to be established in dharma. Udyuktam. Udyuktam, he has to have industry. He is not to be lazy or otherwise passive. He has to have an active attitude in his personality. Udyuktam. Krodha varjitam. He should not be given to anger. So such a person, as per Katyayana, which is again reiterated. So we find that these various commentators are quoted. So Katyayana is now quoted by Vijnaneshwara in his commentary. So that becomes reinforced. What Katyayana has said has been reinforced by Vijnaneshwara. Similar to how we refer to various judgments or various other sources in our present day publications or literature. Iti. Evam bhuta brahmana sambhave. If such a learned brahmana with these specific qualities is not available, Kshatriyam Vaishyam va Niyanjita. Either from the political class, Kshatriya, or from the business class, somebody who has been a Vaishya has to be Niyanjit, na Shudram. So here he has said a person who is not having access to learning, such a person should not be represented as a chief justice here or chief judge here. Yathaha Katyayanaha Brahmano yatra nasyatu Kshatriyam tatra yojayet Vaishyam va dharmashastrajnam Shudram yajnena vartayet. A similar aspect has been propounded by Katyayana. Iti. Naradena to ayameva mukhyo darshitaha. The same aspect has been presented by Narada, another commentator, another judicial commentator. Dharmashastram puraskritya pradvivaka mate sthitaha samahita mate pashyed yavaharan anupravat. So this person, this chief judicial officer who is a representative of the executive power, the word used is prad vivak. This is the word used for a chief judge, prad vivak. And samahitamatihi pashyat vyavaharan anukramat. So this prad vivak has to be the person advising the ruler on how justice administration has to be done. Prad vivak mate sthito nas pamate sthitaha. तो ये भी यहाँ पे स्पष्ट किया गया है कि जो समाज का नेता है उसको अपने ही विचार के अनुसार नहीं चलना चाहिए, परंतु प्राण विभाग के एडवाइस के आधार पर चलना चाहिए. तो प्राण विभाग मते स्थितो न स्वमते स्थितः राजा चार चक्षुषा परसैन्यम पश्यति इति वत्. जैसे राजा दूसरे प्रदेश में दूसरे सेना के विषय के बारे में चार या जो गुप्तचर के द्वारा उसका ज्ञान पाता है, वैसे ही न्याय व्यवस्था के विषय में राजा को प्राण विभाग के उपदेश अनुसार अपना आचरण करना चाहिए. प्राण विभाग मते स्थित है. तो the king has to, or the ruler or the executive has to have a sense of boundedness by the advice of the prad vibhag. Tasya cheyam yogiki sangya. So how the word prad vibhag is derived is also described by Vijnaneshwara. Arthi pratyarthinau pruchhati iti prat. The word prat is describing the fact that arthi is the plaintiff, pratyarthi is the defendant. So the plaintiff and the defendant are asked or are indulged in discussion. That word is prat. Tayor vachanam viruddham aviruddham vividham cha sabhyai saha vivinakti vivakti va vivechayati veti vivakaha. The word vivak means that after hearing both the sides, after hearing the plaintiff and the defendant, along with the members of the committee, which have also been appointed by the executive power, he discusses which is correct, which is viruddha, which is aviruddha, which is acceptable, which is not acceptable. And that contemplation and discussion is headed by him. And that is the word vivak. The prat chaso vivakashteti prat vivaka. So he is leading the process of judicial administration. He engages with the plaintiff and defendant. He engages with the judicial committee, discusses about the pros and cons of both of these sides, and comes out with a decision. So that is why he is given this title of Prad Vibhag. Uktam cha vivadanugatam prishtva sasabhyas tat prayatnatah vicharayati yenasau pradvivakas tatasmritaha. So the word pradvivak is coming from the fact that he has to enter into the facts or the details of the vivada or the dispute. विवाद के विषयों में प्रविष्ट करके सभ्य सभासदों के साथ प्रयत्न के साथ वो जब विचार करता है विवाद के बारे में, इसीलिए उसका नाम प्राड विवाक ये रखा गया है. So that is the third aspect of third provision in Yajnavalkya Smriti, where there is a discussion on how the procedures and the processes for judicial administration are set in place. Now coming to the next aspect, what is the consequence of the members? यदि सभा में नियुक्त जो विधि के विवेक को देखने के लिए जो सभासद हैं या प्राण विभाग है, अगर वो च्युत हो जाते हैं, if they make mistakes or if they commit errors in judgments, wanton errors in judgments, what is the consequence? तो अपि च प्राण विभागादयः सभ्या यदि रागादिना स्मृत्यपेतं व्यवहारं विचारयन्ति तदा राज्ञा किं कर्तव्यम् इत्यतः. So if the members, including the Prad Vivak, if they act in a manner on account of various personal vices, because of various prejudices, if they act in a manner which is opposing the Smriti, opposing the nature of dharma as has been described in the Dharma Shastra, what has to be the punishment to be meted out to them by the executive? That is discussed here. Raga, Lobhat, Bhayad Vapi, Smritya Petadikarinah, Sabhyah, Prithak Prithak Dandya, Vivadad, Vigunam, Damam. So, because of either favoritism, Raga, Lobha, because of greed, because they have accepted some kind of consideration for a decision, Lobha, Bhayad, if out of fear, if any of these members of the Sabha and the Prad Vivak, if they have taken a decision which is contradicting what should have otherwise been reached in accordance with the Smriti, they are to be penalized an amount as to 2 times at least Vigunam, the amount. Each of them have to be penalized twice the penalty that is the consequence of the decision that they have taken. Purvokta Sabhya Rajaso Nirankushatvena. So Vijnaneshwar, because we have to keep in mind that Vijnaneshwar himself was towards the end of his life, he has reached the stage of a Paramahamsa. That is a person who has transcended social norm, in the sense that he became a true sannyasi, so to say. So he has that kind of a vision towards human conduct. And so he points out that why there is a transgression, why kyun bhrashta hote hain sabhasad. That reason he is giving out because of rajasaha nirankushatvena. Because out of sattva, rajas and tamas, the passionate aspect of their living, if that goes out of control and that is not controlled by sattva, which they are supposed to do because of their nature of dhamma, rajasaha nirankushatvena tad abhibhuta ragat sneha atishaya. So what is the meaning of raga? Is sneha atishaya, an excess liking towards a particular, that is they are exposing their prejudice. Ragat sneha atishaya. Lobha is lipsatishayat, excessive desire for a particular object. Lipsatishayat. Bhayat samtrasat, out of fear. Smritya petam smriti viruddham. So if they act in a manner which is against the smriti, which is clearly wrong, evidently a miscarriage of justice has occurred, and it is brought to the notice of the executive, the ruler, who is eventually in charge of ensuring that judicial administration is properly conducted. Adi Shabdat Achara Petam Kurvantaha. So either it is against the Smriti or against the norms, whatever is the achara that is prevalent in that society, if some decision has been taken against that in a manner that is clearly incorrect. Prithak Prithak Ekaikasho Vivadat Vivada Parajaya Nimittat Damat Dvigunam Damam Dandya. So each of them, not all of them taken together, each of the members of the Sabha has to be penalized to the extent of twice the outcome of the decision. So usually if there is a commercial decision and they have held in favor of one person and therefore kept some penalty on the other person, the fact that they have indulged in a wrong decision should lead to their being penalized twice the outcome of the dispute. So tamam dandya na punar vivadaspadi bhuta drapya tatha sati stri sangrahanadisho danda bhava prasangana. So it is the penalty that has to be doubled and applied to each of the wrongful judicial members. Ragalopa bhayanam upadanam ragadishreva dviguno damo na ajnana mohadishriti niyamartham. So they're again clarifying that it has to also be established that there has to be a mens rea. That is, there has to be a clear cause as to why they have taken a wrong decision. There has to be raga due to favoritism, lobha due to some kind of a consideration that they have taken, or bhaya out of fear. That has to be established. Merely their ignorance, or if they have taken a wrong decision on account of moha, or they're not having applied their mind correctly, moha or agyan के कारण यदि कहीं च्युति हो गई हो, उसके कारण उनको दंड नहीं मिलेगा. केवल यदि राग लोभ भयादि उनके आचार में विरोध यदि प्रकट हो गया हो, if it is established and evidenced that there is an error of judgment that has taken place on account of certain aspects of their behavior, only that will lead to penalizing them. Nacha raja sarvasyeshte brahmana varjyam iti gautama vachanat na brahmana dandya iti mantavyam. So here there is an interesting discussion by Vijnaneshwara, because as we have seen, most of the members of the Sabha, including the Prat Vivak, all have been asked to be appointed due to their qualification of being learned Brahmanas. Whereas there are also mentions in various smritis that Brahmanas are not to be punished or penalized. So the question that Vijnaneshwara brings to the fore now is whether there is a contradiction between these two sentiments or aspects. So on one hand, if your appointee judicial members are found to have taken have taken an incorrect decision on account of established defaults on their part, they are to be penalized. On the other hand, we have provisions in the Smriti that says that Brahmanas are not to be punished. How this is reconciled? This discussion by Vijnaneshwara is interesting. Tasya prashamsarthatvat. So he only says that na brahmana dandya is only for the purpose of for bringing out their as a sense of it's only a formal statement. It's not an absolute statement. Yattu shadbhihi pariharyo rajnya. So there is a statement that he's again recounting from the Smriti. Avadhyascha, abandhyascha, adandyascha, abahishkaryascha, aparivadyascha, apariharyascha. So these 6 punishments are not to be meted out to a Brahmana, which says avadhya, he is not to be killed. Abandhya, he is not to be incarcerated. Adandya, he is not to be punished. Abahishkarya, he is not to be excommunicated. Aparivadya, he is not to be insulted. And apariharya, his property is not to be taken away. But all of this is only applicable to sa esha bahushruta bhavati, loka veda vedangavit. So only a person who has attained a certain higher level of learning, it is not merely for all Brahmanas. So therefore it is not applicable. These aspects of prohibition are not applicable to all Brahmanas. They are only applicable to a select few who have gone through various levels of learning and who are at a certain position of having exercised their learning, etc. Loka Veda Vedangavit. Vako Vakyeti Hasa Purana Kushalaha Tad Apekshas Tad Vritishcha Ashtatvatvarimshat Samskaraihi Samskrata. So somebody who has been who has 48 samskaras. So those 48 samskaras are also mentioned here. Trishu Vada Dvigunam Tat Dvigunam Cha Raja Tatha Cha Vakshati Atha Kim Raja Swapurushair षट्सुवा सामय चारिकेश अभिनिवीतः इति प्रतिपादित बहुश्रुत Vishayam karma na brahmana matra vishayam. Just to understand that Vijnaneshwara has pointed out that these are the various on the screen, as you can see, 48 different samskaras, and these are very rare. These are not commonly seen in the general class of brahmanas, and definitely not expected to be seen in people who are participating in these activities. So it's only a very select class who have attained all these various levels of learning and conduct, who are supposed to be beyond reproach, etc., who are who have the protection from being punished by the king. Whereas since it does not apply to everybody in general, so therefore this provision of punishing members of the sadas or the prad vivak on account of misconduct is very much applicable. So therefore there is no prohibition with respect to their having to face the punishment. So that is one discussion by Vijnaneshwara. Now we come to the definition of Vyavahara or disputes itself. Vyavahara Vishayamaha Smrityachara Vyapetena Margena Adharshitah Paraihi Avedayati Chet Ragnye Vyavahara Padam Hitat. So Vyavahara is described to be that which is any contradiction to the path which is mentioned in the Smriti and Achara. So conduct and what is provided in the Smriti, if there is a conduct that is contradicting that or contravening that by another person, and if there is a complaint made, Avedayati Chet Ragnye Vyavahara Padam Hitat. So that becomes a Vyavahara. Vyavahara becomes a dispute which is brought to the notice of the executive or the person who is in charge of the well-being of society. If that ruler has been approached with a particular dispute where there is a clear mention of some aspect of achara or behavior or smriti or the dharma shastra having been contravened, that becomes defined as a vyavahara. And all that follows in the vyavahara pada, in the vyavahara chapter in Yajnavalkya Smriti is to deal with these various aspects of vyavahara or disputes. Dharma Shastra Samachara Viruddhena Margena Parair Adharshito Abhibhuto Yad Ragnye Pradvivakayava Avedayati Vignapayati Ched Yadi Tad Avedyamanam Vyavahara Padam Pratignottara Samshaya Hetu Paramarsha Pramana Nirnaya Prayojanatmako Vyavaharas Tasya Padam Vishayaha. So this, what becomes the subject matter of Vyavahara is Dharma Shastra Samachara Viruddhena. So what is mentioned in the Dharma Shastra with respect to how human conduct should be followed, jaise achar hona chahiye Dharma Shastra ke anusar, and Lokachara, and the conduct that is established in society and accepted to be correct. If there is something against that, so there is a deviant action that is there in society, and that deviant action leads to the loss or damage or abhibhava, that is somebody else is affected. So one person is deviant, another person is affected by the deviant behavior, and the person, the plaintiff or the complainant who is affected by the deviant behavior, he comes up to the Prad Vivaka or to the Raja, to the judge or to the king, and he explains his position, he relates his position. That becomes a Vyavahara. So it is only when all these conditions are fulfilled that it becomes a dispute that has to be dealt with by the dispute resolution mechanism set up by the state. Chetyadi tad avedyamanam Vyavahara padam. And in that process of Vyavahara or dispute resolution, you have these various components like pratigna. Pratigna is the statement. What is the dispute? Uttara, the response of the defendant. Samshaya, there will be doubts because with both parties having different positions, there will be some doubts that come up. Hetu, so how those doubts have to be resolved, there will be some reasoning. Paramarsha, that is the discussion. Pramana, evidences placed for the purpose of resolving the dispute. Nirnaya, decision. And then these are all components that go into the dispute resolution process. These are all various stages of the dispute resolution process. And all of that taken together is considered as vyavahara. Is ye sab अवयव, ये सब जो जब एक साथ मिलते हैं, प्रतिज्ञा होना चाहिए, उत्तर, संशय, हेतु, परामर्श, प्रमाण, और अंत में जब निर्णय होता है विवाद के समाधान के लिए, ये सब मिलके व्यवहार नाम से कहलाते हैं. व्यवहार तस्य पदम विषयः. तस्य चेदम सामान्य लक्षणम. दिस इज द जनरल डेफिनेशन ऑफ व्हाट इज व्यवहार. सच द्विविधः शंकाभियोगः तत्वाभियोगश्चेति यथाह नारदः. So there are two types of vyavahara. One is shanka. Abhiyoga is a complaint or is an accusation. So one accusation is an accusation where it is not certain that a person has committed a crime or committed a wrong. So it is only a doubt is expressed. Shanka abhiyoga and tatva abhiyoga, when the complainant says with certainty that the defendant or the accused has committed a wrong. So there are two types of divisions here. Yathaha naradaha abhiyogasto vignyayah shanka tatva abhiyogataha. So these are two types of classifications. Shanka asatam cha samsargat. So shanka, the shanka abhiyoga, the accusation which has an element of doubt in it, is one where there is an association, samsarga, with wrongdoing person. So therefore, it is only on account of association of the accused that you assume that the accused has committed a particular wrong. Shanka satam to samsarga tatvam hodhabhi darshana. So where the complainant is certain that the accused has committed a particular crime or wrongdoing, that is where there is certainty, it is tatvam. Where there is doubt, it is shanka. But in all cases, he brings the complaint to the pradvivak. Iti. Hodha loptram lingam iti yavat tena darshanam sakshatva darshanam hodha vi darshanam tasmat. So when the complainant is sure of the commission of the wrong by the accused, it becomes a tatva bhiyoga. And again, tatva bhiyoga api vividha. There are two types of complaints or accusations. One is pratishedhatmako and vidhyatmakascheti. So one type of wrongdoing is when a person who is not supposed to do something, he does it, or he doesn't do it. That is, a person who is supposed to have taken certain actions does not do any action, that becomes pratishedhatmako. And when a person who is not supposed to do a particular activity indulges in a particular action, that becomes vidhyatmakascheti. Yatha. Example, matto hiranyadikam grihitva na prayachati. So one person has borrowed or taken hiranyam, or any kind of hiranyam is gold. So hiranyadikam grihitva, one person has borrowed or taken a particular material from the complainant. So the accused has taken some hiranyadikam from the complainant and na prayachati. He is not returning it. So therefore he is supposed to take an action, he does not do it. That becomes pratishedhatmako. And second example is kshetradikam mama ayam apaharati. So my land, my property is being taken away by another person. So that becomes, he does an action which is supposed to be prohibited. So he commits a crime essentially. So kshetradikam mama ayam apaharati. That is the second type of accusation. So this is a further classification of accusations. Uktam cha katyayanena. So Katyayana has thrown some light on this. Nyayam swam nechate kartum anyayam va karoti yaha. So these are the two types. What is supposed to be done, what is nyayam, if he does not do, and what is not supposed to be done, that is anyayam, if it is done. These are the two types of wrongdoings, crimes, or complaints, subject matter of complaints, which can be brought to the notice of the pradvivak. Iti. Punascha ashtadashadha bhidyate. So one classification of all types of wrongdoings that can be brought to the notice of a court, there are 18 types that have been suggested. Yathaha Manu. In the Manusmriti, there are 18 types of wrongs or crimes that can be brought to the notice of the dispute resolution authority. Tesham Adyam Runadana. First Out of 18, one is Rinadanam, not returning debt, not non-repayment of debt. Nikshepo, if something has been kept in trust and if it is not given back, that becomes Nikshepaha. Then Aswami Vikrayaha, selling without title. If you are not the Swami of an item, not the owner of an item, and if it is being sold, it becomes Aswami Vikrayaha. Sambhoya cha Samutthana. So this is where groups of people come together to perform certain tasks or businesses, where in the form of a partnership or company, Sambhoya, and out of that there are disputes. There are disputes out of actions taken together as a partnership or as a company. So that becomes another class of disputes. Sambhoya cha Samutthana. Dattasya Anapakarma. What is given is not returned. So that is another one type of dispute. Vetanasyeva Chadanam. So if there is a Vetanam or a particular amount, remuneration that has to be paid, and it is not paid, that becomes a dispute. Samvidascha Vyatikramaha. Samvid is a promise, and what we understand in our profession as a contract. And if a contract is broken, that becomes another type of dispute. Samvidascha Vyatikramaha. Kraya Vikraya Anushayo. So when there is a sale of any item, and there is a lack of satisfaction, Anushayaha, on account of that sale, that lack of satisfaction, consumer can bring it to the notice of the dispute resolution forum. Vivadaha Swami Palayoho, master and servant, when there is a dispute between master and servant. Sima Vivada Dharmascha, when there is a boundary dispute between properties. Parushye, when there is insult or loss of reputation of a person, that becomes Parushyam. Dandavachike, Steyam, theft. Sahasam is assault, physical assault on a person. Chaiva, Stri Sangrahanam. Stri Sangrahanam is crimes on women in various forms that can be thought of. So Stri Sangrahanam. Stripam Dharma, the dharma between a husband and wife or a man and woman, where that comes apart, that becomes another reason for dispute. Vibhagascha, distribution or property distribution. Dyutam, Ahvaya. So there is any dispute related to gambling. All of these evacha. Padan Yashtada Shaitani Vyavahara Sthitaviha. So this is one classification of around 18 type of disputes mentioned in the Manu Smriti. But it is again mentioned that Etan Yapi Sadhya Bhedena Punar Bahutvam Gatani Yathaha Naradaha. So these are 18 possible types of disputes that have been mentioned here. But it is also acknowledged that there can be many other types, because each of these can have various subjects. So in case of debt, it can be many types of debt based on gold, on money, on property, etc. There can be many types of contracts. There can be many types of remuneration, master-servant relations, etc. So there can be multiple. These 18 itself can be divided into many other types of disputes. Yathaha Naradaha, Esham eva pradhedonyaha shatamashtottaram smritam. So Narada has said another division of disputes can be made which is more than 108 in number. Shatamashtottaram. Kriya Bhedan Manushyanam Shatashako Nigadyate. Even that becomes multiplied into many types of disputes. So therefore, although for convenience you can say there are 18 types of disputes or 108 etc. types of disputes, the actual disputes will depend on the facts of each case, and there can be multiple types of disputes. So that is acknowledged. Iti Avedayati Ched Rajñe. So another aspect of the dispute resolution is that action is not to be taken suo moto. That is, only disputes that are brought to the attention of the court, in this case the Prad Vivak, only those have to be dealt with. Avedayati Ched Rajñe Ityanena Swayameva Agatya Avedayati Na Raja Preritaha. So यदि कोई विवाद राजा के समक्ष आता है तो राजा को उसका समाधान के लिए प्रयत्न करना चाहिए. ये नहीं होना चाहिए कि राजा स्वयं प्रेरित करके विवादों को उठाए. So the ruler or the state itself should not reach out and try to seek the formation of disputes. Disputes have to be brought to the knowledge of the dispute resolution forum, in this case the Prad Vivak. Raja Preritaha तत् पुरुष प्रेरितो वा इति दर्शयति यथा मनुः नोत्पादयेत् स्वयं कार्यं राजा वाप्यस्य पुरुषः न च प्रापितमन्येन ग्रसेदार्थं कथञ्चन. So it is clarified that disputes should not be sought out by the state. Only disputes that come naturally in the course of the dispute having been formed, etc. So there, one should not precipitate disputes, so to say. The ruler is not here to precipitate disputes because there can be any number of disputes that are there in human society. Only those that have reached a level of importance or gravity that it is necessary to be brought to the notice of the court appointed by the state in the form of the Prat Vibhag, only those disputes have to be engaged with. So that is one aspect of dispute resolution, because it is very much possible that certain disputes will be resolved by themselves, which do not need the attention or the resources of the state for their resolution. Only those who have locus standi are permitted to bring disputes. Locus standi is those who have a stake in the subject matter of dispute. They are allowed to bring the disputes. It is not to be disputes brought by a third party is not to be entertained, is also mentioned. Iti parairiti parena parabhyam parairiti ekasyekena dvabhyam bahubhirva vyavaharo bhavati. So there can be disputes of one person with multiple persons. It is not just one-on-one. There can be multiple persons on the other side as well. Yat punaha ekasya bahubhihi sardham strinam preshya janasya cha anadeyo bhavet vado dharma vidbhir udahrataha iti Narada vachanam tad bhinna vishaya sadhyam. So Narada, in one of his discussions, has pointed out that there should not be dispute of one with many, or there should not be disputes with women, etc. There is some discussion of Narada. So that Vijnaneshwara has clarified that that statement of Narada is with regard to disputes that have multiple causes of action. If a dispute has many causes of action, which has many subjects, those have to be split into multiple disputes, should not be brought in as a common dispute for the purpose of ease of dispute resolution. The Avedayati Ragnye ityanenaiva Ragnya Prushto Vinita Vesha Avedayat. Now, how this process of bringing matter to the notice of the Raja or the Prat Vibhag that is discussed here, it is Avedayati Ragnye Vinita Vesha. So the person bringing the dispute to the notice of the state has to come in a humble way, and he has to describe, first state what his trouble is. Aveditam cha yuktam chet mudradina pratyarthya ahvanam akalyadinam cha anahvanam ityadyartha siddham iti noktam. So the next stage, which is not mentioned in the Yajnavalkya Smriti, is being completed by Vijnaneshwara, where he says that once a humble plaint has been brought to the notice of the court, Aveditam cha yuktam chet, prima facie, if it appears to be correct, mudradina, with the seal of the court, with the seal of the ruler, which has been given to the Prat Vibhag, mudradina, pratyarthi ahvanam akalyadinam cha anahvanam ityadi. So whoever is the accused, whoever is the defendant who has been brought to the notice of the court by the complainant, that person has to be summoned to the court. That is the next step. That has not been dealt with in Yajnavalkya Smriti, but is being detailed by Vijnaneshwara in the Mitakshara, how that has to be done. So pratyarthi ahvanam and akalyadinam. If the accused is not well, or he is not in a state to travel to the court, that process of summons can be delayed. Cha anahvanam ityadi artha siddham ti noktam. Smrityantare tu spashtartham uktam. In other smritis, it is described in detail. That process, the entire process of the complainant coming to the court, bringing his matter to the knowledge of the court, and the court then summoning the accused, the opposite party. Yatha kale karyarthinam pruchet pranatam puratassthitam kim karyam kachate pida mabhaishir bruhi manava kena kasmin kada kasmat पृच्छेदेवं समागतम् एवं पृष्टस्य यद् ब्रूयात् सभ्यैर् ब्राह्मणैः सह विमृश्य कार्यं न्यायं चेत् आह्वानार्थम् अतः परम्. So in the other smritis it is mentioned that is kale karyarthinam, when the complainant comes to the court and when he is in a humble way submitting himself to the power of the court. So that is important. So whoever makes the complaint has to acknowledge the power of the court to resolve the dispute and in a humble manner bring it to the notice of the court. Prichet, pranatam, he prostrates himself. And the court, the sabha, led by the Pradvivak, has to ask him, Kim karyam, what is your problem? Kachate pida, aapko kya pida hui hai? What is the trouble that is, what is it that is troubling you? Ma bhayushihi, do not fear. Without fear, explain to this court what is your problem. Kim karyam kachate pida, ma bhayushir bruhi manava. Hey manava, hey human, bring it to the notice of the court. Kena kasmin kada kasmat pritchedevam sabhagatam. So he has to then, once the Sabha asks him these questions, he has to say, who has caused me problem, in what manner, when, etc. All that he has to give in some brief detail to the court. Evam prishtasya yad bruyat sasabhyair brahmani saha vimrushya karyam nyayam ched ahvanartham atapram. So they, once the matter is brought before the court, there is a discussion amongst the court members, including the sabhasadas, and it is decided whether to call for the other party or not. Mudram va nikshipet tasmin purusham va samadishet. To give effect to the summons, the seal, the mudra is put on a particular summons paper, or the official of the court is sent for the purpose of bringing the accused before the court. Akalya balasthavira vishamastha kriyakulan karyatipati vyasani drupakaryotsavankulan. So such persons are not to be disturbed. So there is an exception to the rule as to who can be brought to the court as accused. Akalya, if a person is unwell. Bala, if he is a minor. Sthavira, very old. Vishamastha, in difficult times. Kriyakulan, he is involved in some particular urgent activity. Karyati pati vyasani, or he is doing some particular activity, or he is in some kind of trouble. Drupakaryotsa, he is engaged in work of the state. Utsavakulan, or is having some kind of family celebration, etc. Some celebration is going on. Matton matta, if he is of unsound mind. Pramatta, artan, vrityan, nahvanayed nrapa. So such persons are not to be immediately summoned. Na hina paksham yuvatim kule jatam prasutikam, or a woman who is in difficult times, or she is in a troubled state, or if it is a young woman, or a woman who belongs to a family, which an established or a reputed family, or prasutikam, a pregnant woman. Sarva varnottamam kanyam, if it is a kanya of a good family, ta jnati prabhuka sprita, those kind of women have to be represented by their jnatis, by their relatives, male relatives. But there are certain women who are recognized to be those who are independent. Tadadhina kutumbinyaha, if a woman is the head of the family and she is running the family and the family is dependent on her, so she is an independent woman. Svairinyaha, a free woman. Ganikaha, a certain type of class of women. Nishkulayaha, a woman who is not of a family, part of a family, but free and independent. Patitas tasam ahvana vishyate. Those kind of women can be directly called because they are having an independent position in society. Kalam desham cha vijnaya karyanam cha balabale akalyadi namapi shanair yanair ahvana yen nrapa. So after seeing the situation, after understanding their position, even those who are at that point of time unable to come and be present in relation to the summons, they have to also be slowly be brought to the. So that is another aspect of the summons procedure. So should we take a break now, or?
Sir, I think we also can request the Honorable Vice Chancellor of Central University, Sri Bhattu Satyanarayan, to address his presiding note so that we can continue this session tomorrow. subject to what the other participants would say. But I feel stretching beyond a certain limit would not be so conducive to have our attention continuously. So, may I now, before I request the Honorable Presider, the Honorable Vice Chancellor to speak, there can be a question and answer session. Those who want to pose any question or give any clarification by themselves to this talk, today's session, or who want to add something in brief, in short, may please raise their hand or unmute themselves or request for an unmute, put up their video. ಸರಿ, ಯಾರಿಗಾದ್ರೂ ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳೋದಿದ್ರೆ ಕೇಳಬಹುದು. We will have this question and answer session for 2 to 3 minutes.
ಕ್ವಶನ್ ಇಂಗ್ಲಿಷ್ ಹಿಂದಿಯಲ್ಲಿ ಬರ್ಲಿಕ್ಕೆ ಕನ್ನಡದಲ್ಲಿ ಕೇಳಬಹುದು. ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅವರು ಅದನ್ನ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ. ಭಾಷೆ ಸಲುವಾಗಿ ಹೆಸಿಟೆಂಟ್ ಬೇಡ. ಈಗ ನಿಮ್ಗೆ ಯಾವ ಭಾಷೆಯಲ್ಲಿ ಬರುತ್ತೆ ಭಾಷೆಯಲ್ಲಿ ಕ್ವಶನ್ ಕೇಳಿ ಉತ್ತರ ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅವರು ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಸರ್,
ಕೃಷ್ಣನ್ ಅವರು ಹಿಂದಿಯಲ್ಲೂ ಕೂಡ ಮಾತಾಡಬಹುದು, ಇಂಗ್ಲಿಷ್ ಅಲ್ಲೂ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ. ಯಾರಿಗೂ ಕನ್ನಡದಲ್ಲೇ ಕೇಳೋದಿದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಪ್ರಶ್ನೆ ಕೇಳಬಹುದು, ಅಥವಾ ತಮಗೆ ಏನಾದ್ರು ಕನ್ನಡದಲ್ಲಿ ಇದನ್ನ ಇನ್ನು ತಮ್ಮ ಕಡೆಯಿಂದ ಏನಾದ್ರು ಹೇಳ್ಬೇಕಂತ ಅನ್ಸಿದ್ರೆ 1-2 ನಿಮಿಷದಲ್ಲಿ ನಾವು ತಿಳಿಸಬಹುದು ಸಭೆಗೆ. ನಾವೆಲ್ಲರೂ ಕನ್ನಡದಲ್ಲೂ ಕೇಳಬಹುದು. ನಿಮ್ಮ ಕನ್ನಡ ಪ್ರಶ್ನೆಯನ್ನ ಅನುವಾದ ಮಾಡ್ತೀನಿ ನಾನು, ಅವರ ಉತ್ತರನ್ನ ಕೂಡ ನಾನು ಅನುವಾದ ಮಾಡಬಹುದು, ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. Krishnan sir, I assume that the audience is not having any queries, right?
The idea was to just give a sense of how these processes were thinking of Vijnaneshwara, how he himself, because now we are talking about Vijnaneshwara, to understand the person, it's the best way is to see how he has presented various aspects. Of course, it's a very, the text itself is quite lengthy and detailed. It's a lifetime effort by Vijnaneshwara. So in this short webinar, the idea is to get a sense of how he thinks and how he tries to deal with various opinions that pre-exist him.
In addition thereto, the idea of these webinars is in fact to sensitize people and students, and in fact to provoke them or to inspire them to have an in-depth study of Mitakshara. So we cannot, I know, in 3 sessions or even in the 10 sessions, we would not be able to conclude the whole of the text. So students would be inspired by this study and your erudite explanations also. That's the idea, sir. Now may I request Sri Batu Satyanarayana, the Honorable Vice Chancellor of the Central University, to give his presidential remarks.
Today, very I am excited by the lecture given by the Krishnanji and the Mahadevaji and Amit Kumar Deshpandeji. Today, this will be very useful lecture. This is, but if I decided if we prolong it again, may not digest, because it is very difficult to concentrate on this one. It is very lengthy and very interesting, and we cannot go through the total constitution in a single day or 2 days. Like this, it is more than the Constitution of India. Now, this is Mitakshara. I'm just, before that, I didn't know about this Mitakshara. After joining at SQK, Kalaburgi, I came to know that this is a Vijnaneshwara who worked under the Western Chalukyas. I developed this Mitakshara, and this is the birthplace for this Mitakshara, that is a foundation for the Hindu laws. I'm really excited after hearing this For the first time, only I came to know that Mitakshara is located nearby the Kalaburgi. Now today I have seen what is the Mitakshara, how is narrated, everything is that is available in the Sanskrit, and every detail are available in this Mitakshara. So how they developed in that means knowledge, whatever they have at that time, and whatever the problems facing the society based on, I think based on that they might have developed this one. So because of the foreigner rulers, our these laws have not been developed. And now after this during Britishers, always we are coding about the IPC, CRPC, everything. But if you go to this law, I think every solution is available, I think, in this one. So definitely this will inspire particularly the younger generations, the students. Now, fortunately, we also have the law in PG. Definitely, I'm also planning to start the UG in the law. Definitely, that will benefit the students. Definitely, we'll take the inspiration from this place, the Mizakshara, because it is a birthplace for this Hindu laws. Definitely, if we start the BA, that is for 5 years course, so that is LLB, then that will be most useful, and students also will be inspired by this Vijnaneshwara and the Mitakshari. So that's most useful for us. So because I from the law, know very little bit law. So whatever is there, I am trying to understand myself about this laws. Definitely this definitely benefit the students. I will also invite the Krishnanji to our university also to give lecture on this one. Definitely this will inspire. With this, I thank the organizers for giving this opportunity. Thanks, Madam.
Thank you, sir.
Thank you, sir. Dhanyawada. Now, may I request Sri Mahadevaya Karadalli ji to propose the vote of thanks to the honorable guests and the participants.
The second day of lecture series, I thanks on behalf of Vignaneshwara Pratishtana to grace this occasion by Honorable Vice Chancellor, Central University of Karnataka. Sir, I am pleased to inform and thankful to you. Your students were present yesterday, the immemorial day of in the history of law. Yesterday, 900 years back, Chalukya Chakravarti Vikramaditya visited Martur to honor Vignaneshwara. Your students were witnessed the occasion. I thank you, sir. So I am thank you for your remarks that you will open UG course in law. I thank you, sir. I request you that in every law syllabus, you please make that internship at Vignaneshwara Pratishtana or visiting Vignaneshwara Bhavan made it is a part of syllabus that we request for you, sir. So another thing is, sir, Central University can formulate, I think Hyderabad Usmania University has formulated in other departments that certificate course in law, various courses which are helpful to the competitive exams. In that case, one chapter is to be including about Mitakshara like that. So I request you that in this backward area, people may not come for graduate or UG or PG. So let them start after SSLC, some 6 months course or 3 months course or whatever, which is helpful for various competitive exams, helpful to the students, so that we can draw the attention of young people who are towards the legal system of India, sir. Thank you, sir, for your advice and guidance, sir. I also thank Sri V. Krishnan, sir. Thank you for continuous studying and enlightening the people. It is a hard nut to understand, but you make it easy, just like the banana. So I think it is a new avenue. People should aware of that one. So people may limited, but they are well interested. Let us be two together. We can make it popularize the Bharatiya jurisprudence with your help and assistance. Thank you. And thanks all the participants, dignitaries, faculties from legal sector, and principals, lecturers, students who are participated today function. I thank you one and all. Tomorrow is the last day of the series, and tomorrow Honorable Vice Chancellor of KSLU is presiding. So I feel students who have participated, let them continue tomorrow also. Feel free to ask Krishnan in any language questions so that he can answer it, and Sri Amit Deshpande can translate on your own language. You will try for the best. Thank you one and all.
Tomorrow with the same link.